The European Data Protection Board's Recommendations 01/2020 on measures that supplement transfer tools to ensure compliance with the EU level of protection of personal data, version 2.0, provide a comprehensive guide for entities transferring personal data outside the European Economic Area, EEA. This document was adopted on the 18th of June 2021, following a public consultation process that started with the adoption of version 1.0 on the 10th of November 2020. It addresses the aftermath of the Court of Justice of the European Union, CJEU, judgment in case C-311/18, Schrems II, emphasizing the need to maintain the high level of protection afforded to personal data under the EU General Data Protection Regulation, GDPR, when such data is transferred internationally. Key objectives and context. The GDPR aims to facilitate the free movement of personal data within the EU while safeguarding the fundamental rights and freedoms of individuals, especially their right to personal data protection. The Schrems II judgment highlighted that personal data protection must travel with the data outside the EEA, ensuring the data receives equivalent protection to that within the EEA. This judgment clarified the validity of standard contractual clauses, SCCs, as a transfer tool but noted that they do not operate in isolation. Data exporters must verify, on a case-by-case basis, whether the destination country's legal framework impinges on the effectiveness of the safeguards provided by the transfer tools under Article 46 GDPR. Recommendations Overview. The recommendations outline a 6-step process for exporters to follow, ensuring compliance with the GDPR when transferring personal data to third countries. 1. Know your transfers. Exporters should map all transfers of personal data to third countries, ensuring data minimization principles are adhered to. 2. Identify the transfer tools. Determine the legal basis for the transfer, whether it be an adequacy decision, SCCs, binding corporate rules, or other mechanisms listed under Article 46 GDPR. 3. Assess the effectiveness of the transfer tool. Evaluate if the law or practice of the third country may impinge on the effectiveness of the Article 46 GDPR transfer tools in the context of the specific transfer. 4. Adopt supplementary measures. If the assessment reveals the transfer tool alone cannot ensure equivalent protection, identify and implement effective supplementary measures. 5. Take procedural steps. Depending on the transfer tool used, certain formal procedural steps may need to be followed when adopting supplementary measures. 6. Re-evaluate at appropriate intervals. Continuous monitoring is required to ensure the level of protection is not compromised. Annexes and examples. The document also includes annexes defining key terms, providing examples of supplementary measures, technical, contractual, organizational, and listing possible sources of information to assess a third country's legal framework. Conclusion. The EDPB's recommendations are a response to the challenges posed by the Schrems II judgment, providing a detailed roadmap for ensuring that data transfers outside the EEA meet the GDPR's high standard of data protection. This guidance emphasizes the ongoing accountability of data exporters to monitor and evaluate the level of protection afforded to transferred data, adapting to legal and technological developments.